Hello and welcome to the meeting of the Licensing Subcommittee of the California Paraprofessional Program Working Group. I will take roll. Brynildson.
Here.
Hamilton.
Present.
Judge Harper.
Here.
And Torres Ambriz.
Present.
Great. Everyone is here. Thank you. And let's see if we have any members of the public that want to comment. We have a couple of attendees. If any members of the public wish to make comment, please raise your hand in Zoom. I don't see any raised hands. So we can go ahead and get started. Just very briefly, the plan for today, this group had developed licensing recommendations, and in fact, those were approved by the full working group in February. But Elizabeth Olvera had raised a question about whether LDAs could be included in the licensing. So we wanted to reconvene to discuss the options there. And in addition to that, I forwarded you a letter from the California Alliance of Paralegal Associations. And subsequent to that letter, they sent some additional comment, and they sent it in the form of a video. It's about 2 minutes long, and I would like to play that for you if that's okay before we get started and hear from Elizabeth. So that's sort of in the form of public comment. So I need to make sure that I turn the sound on when I share. Here we go. And I will play this, and if you can't hear, let me know right away.
Hello, my name is Dina Fischel. I am Advanced Certified Paralegal in Estate Planning and Discovery, California Advanced Specialist in Discovery, and California Certified Paralegal. In my opinion, as President of California Alliance of Paralegal Associations, any paralegal holding the designation CP from National Alliance of Legal Assistants, NALA, or CCP designation from California Alliance of Paralegal Associations has already successfully demonstrated through vigorous examination their knowledge of the core education this California State Bar Paraprofessional Working Group Licensing Committee should consider as a requirement to sit for paraprofessional certification or licensing exam. By considering to even temporary bypassing the core education requirement for CP, ACP, the CCP paralegals, the pilot program would substantially increase the pool of qualified exam candidates. Paralegal certification test, parameters, and eligibility are listed on www.nala.org or www.caparalegal.org. Further, I would consider it an honor if I would be asked to provide this committee with further testimony directly should you need more information. Thank you for your time. Hello,
Sorry. Just gonna stop that for now. This. So I'm just going to go back to the slideshow. So currently, in terms of the prerequisites for eligibility for the program, we've included people with a JD or an LLM from an ABA approved or California accredited law school or registered law school, or a paralegal qualified under Business and Professions Code, Section 6450C, and LDAs who are also paralegals would be included, but we've excluded LDAs qualified under Business and Professions Code 6402.1 A and B. And this is what the requirements are for LDAs under these two sections.
Can I ask a question?
Sure.
Under A and B, are those ways that you could become an LDA today? Or
Well, yes. So yes. So prior to 19. So if someone became an LDA prior to January 1, 1999, then they could have qualified with 2 years of experience providing self-help service. But that eligibility, as of January 1, 1999, was no longer valid. And I would like to actually let Elizabeth answer any further questions along the lines. Elizabeth has joined us to providing any information about LDAs. So is that accurate, the way that I've characterized that, Elizabeth?
Yes, I believe so. So first of all, thank you for the opportunity for letting us have a voice in this. So what I'm trying to do is trying to help the state bar create a program that puts people who have experience and knowledge in helping self-represented litigants with their process, and also to allow them to use the benefits of called the LDA members, or just legal document assistants that are qualified under 6400 Business and Professions Code, who are already business savvy and just an existing workforce that aligns with what this program is all about, access to justice. So with that being said, I know that we were talking about, well, what are the requirements and prerequisites? And we had a class about it, or a workshop about it, prior to the time that we were asked to make recommendations on it. And at that prior meeting, I had disclosed that, LDAs were already doing this work, but that I didn't see that as being something being considered. And so I was told, as long, I said, can we please make sure we include LDAs in this new position for them to be able to sit at the licensing table. We understand that they're going to have to take more courses. They're going to have to do different things. And I understand they're going to do that, but we just want to have the opportunity to start at the same base level as other, like the JDs and other prerequisite requirements. I was told that, yes, of course, someone who's been doing LDA work for 20 years is not going to be excluded from this program. We'd have to look at the recording, but it was a conversation with everyone, with Julia Brynolson and Stephen Hamilton. But please let me know if I misstated your information. But I think we might have been talking apples to oranges. And so now thank you for the opportunity for us to really dig into what I'm referring to and how we can take it from here. So that's where I'm coming from. Linda, thank you for putting that information up. Our first choice is that we adopt all of 6400, subsection A, B, C, and D. Now I'm including C because I reached out to called the professionals and members, and they reminded me that subsection C regarding a paralegal certificate from a secondary institution allows more LDAs to be part of this program, as opposed to the requirements for a paralegal under Business and Professions Code 6450. So we want to make sure our first choice would be that every anyone who qualifies to become a legal document assistant under 6400 Business and Profession Code be allowed to meet the prerequisite education requirements for this program. In the alternative, you know, given the 1999 timelines and all that, another proposal can be, what if we allow, if we set a cutoff date in this program and say, anyone who is an existing LDA as of January 1st, 2021, who holds themselves out to be a legal document assistant can meet the prerequisite requirements to be able to take that licensing exam and do everything else. Let me know if you guys have any questions.
So can you hear me, Elizabeth? This is Julia.
Yes.
Okay, so what I want to contribute is this, is to clarify I remember this conversation and when you were asking if the grandfathered folks were intended to be included, I was probably one of the persons, or not perhaps the person, that said, oh yes, because I was thinking of the grandfathering in clause under 6450, where you're able to be grandfathered in as a paralegal. It's a little bit different date. It's a little later on, but it did cut off several years ago. And I remember discussing that with Stephen. And I think at that point, that may even been before Claudia was part of this, but I can't really recall. In any event,
I remember hearing about this, so I think it was a little bit after.
Okay, good. Okay, so then the three of us would have been there, and I remember discussing the grandfather clause. And what I didn't understand until you brought it to our attention, Elizabeth, that particular day, is that there was a different grandfathering in clause under LDAs. So what I now understand is, I guess what I'm saying is, having reflected upon this and looked at it, now I hadn't ever considered all LDAs would be eligible to do this. I was thinking only of the immediate issue that you raised after we voted on the licensing framework, was that I considered it saying, okay, if they've been doing this work since 1999, that's now 22 years. And my feeling is, at least as of those people, I'm not so sure as to the other LDAs, but as to those people, I would feel comfortable of them being eligible to participate, but I would not be willing to approve them of having any waiver rights of any of the academic or experiential requirements, because LDAs have been operating much differently than a paralegal who works only under the supervision of an attorney. So in any event, that is why I understand the need. I think the Board of Trustees would want us to include folks who've been doing this kind of legal work for 21 years, but I would not be willing to say they would have the same rights to seek waivers of any academic side or experiential side, because their work path has been much different than that of a paralegal. I don't think that I can say, you know, so that we would get that group of folks that come in under B, then we get those folks who've been working as LDAs, but also have a paralegal certificate, they would be eligible. And so I think that would include potentially the majority of all LDAs. And I don't know within the population of the other LDAs if I can say I have a willingness to let them participate, thinking they may only have been an LDA for a very short period of time, and so clearly don't have the 21 years of experience working in the legal process. So that's just how I see things at this point. That's my contribution. Stephen or Claudia?
Hey.
Yes, Stephen has his hand up.
So Elizabeth, under A, I think I now understand what the grandfather language is. A high school graduate, somebody who graduates like my son in 2 months, could work under the supervision of an attorney for 2 years and then become an LDA, true?
Only if they were also, sorry. And I'm not saying that I'm the expert on this business and professional code section. I wasn't at the table when they came up with that rule. But yes, it's true. If they can, you're right. If they can get an attorney.
Right.
Sign off.
So, because I think that clause that talks about January 1, 1999 says they can bypass the attorney supervision if prior to January 1st, 1999, they had provided self-help service for a period of 2 years. Okay. So, and then, but B is where they've got a bachelor's. So I guess what I'm thinking is I'm not comfortable, particularly with the vote that occurred on Friday, saying that an LDA who qualifies under subsection A should qualify to become a paraprofessional, because we would be then saying that a 20-year-old who spent 2 years working in a law office is now eligible to satisfy the requirements for the paraprofessional program. B, I'm a lot more comfortable with, because there they've got a bachelor's degree. So that, and I'm just expressing my opinion right now. So I can see, I now understand what the confusion was about the grandfather clause. This is completely different than the issue with the paralegals. But I'm really not comfortable with someone who has a high school diploma only and 2 years of working in a law office being eligible to do the 1-year program to become a paraprofessional.
So,
I have a question about that actually. I don't have experience on how many years you would all be more comfortable with. 25 you're comfortable with, I know that. But so more than 2, like 4 years experience, would that be satisfactory? 5 years experience? How many years of experience would an LDA have to have enough experience to then qualify?
I'm saying under B, C, and D, I'm not really worried about the years of experience as an LDA. I'm saying those would be qualified applicants to the paraprofessional program.
Yeah.
I'm not comfortable with the educational requirement being a high school diploma or a GED under A.
Linda, it would be helpful if you put that statute up, if you could. 64, it's 6402.1. So we could see what we're talking about, A through D.
Yeah, I'm scrolling on my phone. I've got an unfair
What
advantage.
about
I can do that.
And what about the idea that Elizabeth raised of grandfathering in certain LDAs, but not making this in perpetuity in eligibility, satisfying eligibility? I'm thinking about that because it is a significantly lesser standard than what you all originally came up with. And sometimes I've seen these kind of situations navigated by grandfathering groups in, but then you're not carrying it forward in perpetuity.
I think one of my concerns is, if I remember correctly, too, we weren't able to get good numbers on the number of LDAs there were, or any kind of breakdown of how many qualified under subsection A, B, C, or D. Isn't that right, Elizabeth?
So we did an informal poll of the called a membership of about approximately 350, and only 50% of them participated in the voluntary poll. So you're correct that we don't have specific numbers. We don't know what all of California LDAs are. But I did want to respond to your prior comment, Stephen, regarding I don't feel comfortable, where you said I don't feel comfortable allowing someone who has a high school diploma and getting an attorney to sign off on a declaration. However, right now, as it stands, someone can go and get an ABA accredited paralegal certificate, no experience, hands-on experience, or even working with under the supervision of an attorney, can still sit at that licensing exam table and still take the educational credits. So it's not, I don't believe that it behooves us to dismiss those people who have actual knowledge, experience, hands-on training. They know the soft skills necessary. So just because they graduated from a high school or a bachelor's with a bachelor's degree, doesn't make them any less available to sit at the same, they're still gonna have to take the same licensing exam, the same education requirements. So I don't want to mislead everyone with saying that one doesn't qualify and the other one does. I would argue, just to finish my thought, I would argue that someone who has been doing this and hands-on experience has more knowledge than someone who graduated from a paralegal program that is ABA accredited or not. They still have a lot of, they're textbook smart, but they're not streetwise. And that's what you need in order to help the target demographic that this program is, and the state bar is set to help and excluding these LDAs from being able to just sit at that table, just to be on the same playing field, is what I'm trying to just bring forward. Thank you.
But we would then be creating a lesser standard for the LDAs than we did for the paralegals, because for the paralegals, in order for them to do the program with only a high school diploma, this is the grandfather clause. They had to be subsection D of 6450, I think. Yeah. When their educational background is a high school diploma, they had to have been working for an attorney for 3 years previously, and that this is the grandfather part. This experience and training shall be completed no later than December 31st, 2003. So when they created the paralegal program, there was a large group of workers that were doing paralegal services, having not gone to school, and that was the grandfather clause. And otherwise, I don't think a high school diploma only will allow someone to become a paralegal, right, Julia?
Okay, I need to back up for a minute. That grandfather in clause contemplated people who just had a high school diploma. And what I think we're saying here, I think that we're getting confused. Currently, based on my read of this statute, no high school graduate is eligible to become an LDA. Only high school graduates who had 2 years of experience prior to January 1999 were grandfathered in under A. So I'm not seeing that there is any grandfathering in of any high school student LDA after 1999. Am I correct, Elizabeth?
No, I don't think that's right.
I don't think so either, Julia.
I'd ask Judge Harper or Greg, the great legal minds on the call, but that's not how I read this statute.
And Lynn, thank you for
I do.
Oh, Justice,
I just wanted to thank you for excluding me from the great legal mind, so I don't have to chime in.
Yeah, Justice Petrie, you and I can get, I guess we got sent to the bench.
I'll just sit here quietly. Take it away.
Please.
Well, we would like the great legal minds to tell Julia Brynelson if she's reading subdivision 8 correctly. I read this to say that you had to have been a high school graduate and had 2 years of law-related experience under a licensed attorney prior to January 1, 1999, or you don't qualify as a high school graduate. That's how I read subdivision A.
I was hoping I can share my screen and share the individual registration application form for becoming a legal document assistant that every county has their own form, and it says there, how do you qualify to be an LDA? And so maybe that'll be helpful how people are qualifying today.
Please.
Yes, please.
So this is a PDF. I'm going to try to make it, this is the whole application. It's individual registration. This is for San Francisco County. It talks about filing fees. You give your personal information.
Can you make it bigger? Okay.
Thank you. Personal information, your date of birth, if you're doing business as a different name. But let me go to the section with education and experience. So some people are going to qualify with, they have earned a certificate of completion from a paralegal program, or they have received a certificate, but not from an ABA approved program, but they also have to qualify with completing a minimum of 24 semester units. Those are the paralegal certificate ones. Here's where we get into the college, bachelor's degree, or high school. As you can see, I don't see a 1999 restriction when you have completed at least 1 year of law-related experience. And with high school, they expect you to have 2 years of law-related working experience.
Do you see, Julie, on the right-hand lower side? That qualifier was if you got your experience in a self-help center, and they cut it off in 1999.
But I guess I was looking at as, but you've been doing, if you're still interested in doing this, to me, I think we're talking about folks that have been doing it for 22 years. You
Right, and
have
they could
to
be doing,
admit
but
all
they,
of this.
yeah.
That's how I read this. Am I?
No, I no, I'm
don't think
saying
a
my son,
current 18-year-old.
yeah, I'm saying my son who graduates this year, if he's been working in my law office for the last 2 years prior to graduation, because it doesn't say you have to have the 2 years of supervision after you graduated from high school. I could take a 16-year-old, have him work for me for 2 years under my supervision, and as soon as they got a diploma, they would qualify to be an LDA.
Yeah, I agree with Stephen. I agree with your take on that.
Thank you.
Okay, so which is this? So this is subdivision D. But what happened? So I didn't really look at D. Weren't we talking about B?
This is A and B.
This is A, yeah, sorry.
A and B. A is
Yeah.
the high school and B is the college.
Okay, maybe it would help if I weren't on this phone. I'm having to make it bigger because I'm, okay. High school diploma.
And Elizabeth, while she's reading it, what I wanted to say in response to something you asked, Stephen, we did reach out to the president of the, I forgot what the association is called. Elizabeth and I talked about this, and she recommended it, and it was a great suggestion to go through the County Clerks Association. Because the LDAs have to register with the counties. And so I made contact with the woman who's the president. Everything looked like it was going well. She said she would distribute a survey for me. We drafted the survey, we sent it to her, and then I never heard from her again. And I followed up several times.
I remember that.
The survey was to go out to all 58 county clerks and see how many of these folks are registered and under which subdivision. But to date, I haven't had any success.
And I remember when I was researching this, if I remember correctly, I tried to go like on a county by county approach, and not every county even has a directory of their licensed LDAs.
Oh, no, yeah.
Am I right, Elizabeth?
Yeah, that's true.
Yeah.
And I can tell you, we don't have any licensed LDAs up here.
You know, for sure.
Yeah.
And what we tried to do was an informal poll, and we asked the membership regarding how did you qualify. And I was surprised to see of all the respondents, it was an equal distribution, 25% through high school diploma, 25% college degree, 25%, if that, counts for anything. So I think that's kind of a small sample, but a representative sample for what it's worth. I just wanted to share.
So if
what would you think if for people who qualified under A, if there was increased experience requirement in the program, so that the experiential learning would be, instead of 1,000 hours, it could be longer than that?
I think
I struggle greatly with a high school diploma or a GED being the only academic requirement before entry into the program. And that struggle is greater in light of our now default position that paraprofessionals are going to be providing in-court advocacy and services.
Yes, I thought we were talking about folks who would have completed high school and done this work by 1999. So now that I've blown this up and taken a closer look, that for those under A currently, it was be my opinion then, perhaps they should have to go to paralegal school first in order to be eligible to enter this program.
You could just say folks who qualify under 6402.1 B, C, or D, and just leave A out altogether.
I think so. I'm
Yeah.
comfortable expanding it, Elizabeth, to B. And from what you're telling us, based on this limited survey you did, that means that would make 75% of the current LDAs eligible, right? Roughly.
Yes.
Yeah, I'm much more comfortable with that.
Yeah,
And
I agree.
are you all thinking about it in perpetuity or as a one-time, grandfathering in anyone who's registered, and there'd have to be some proof of being registered with the county as of January 1, 2021 or something like that?
I think it's in perpetuity, right?
I think it's in perpetuity, but with the understanding that they're not going to be eligible for the waiver of the requirements. They're going to have to take the whole program because, as I previously said, their professional life has been not under the supervision of an attorney. And so that is the dynamic that they're going to have to learn from in terms of, learning more about the practice of law and not just being a document assistant, I think.
And I appreciate that, Julia. And I just wanted to just again comment that, one can argue that, getting a paralegal certificate from an ABA accredited program, but no attorney supervision to be able to sit at this table to take the exam is comparable to someone who's actually been doing the hands-on experience. And so, again, I just wanted for us to stop saying.
Elizabeth, my only response to that would be is from a legal substantive perspective, having done this now for almost 20 years, the scope of education that paralegal students receive is so broad and considerably sophisticated that I am not sure that they are necessarily the equivalent of an LDA who's been doing it more years. You haven't been doing as much legal research and writing and those kind of things. So I just think I understand trying to make it an equivalency. I don't think it's quite that, but I agree with Stephen. If we agree to accept B, C, and D, my only concern would be, even though we're willing to do it in perpetuity, they just wouldn't be able to seek the waivers so that they can go through the experiential and have the more broader substantive legal coursework.
You're saying, Julia, B and C wouldn't be able to seek the waiver, right? Because D is the ABA paralegal program, which already was included and already eligible to seek waivers. So I think it's just if you qualify.
Thank you, Leah.
under
Thank
B
you,
or C.
Leah.
Yeah.
Correct.
Okay.
Thank you.
And thank you, Julia. And I just wanted to remind us that you are correct. The program, I'm thinking about how I qualified the certificate of completion, number C, the letter C. That's how I qualified. And so I had to show my transcript of what classes I took: commercial law, business law. And yes, the program was great. It's now ABA accredited, but it wasn't at the time I took it back in 2003 when I graduated. What we learned then and back then, you're right, it is specialized, but the forms we're going to be doing today and the information is, like divorces and things that people are doing on their own. And so the legal research, I know that in my job, I reach out to attorneys and I'm familiar with the process and we work with attorneys. So even though I'm not being supervised by an attorney, I still choose to have my documents supervised by an attorney on certain occasions when I think it's appropriate. Sometimes I just refer the whole thing out. But yeah, you're right. It's the ABA program is a higher level of education, and the other, bachelor's degree is a different level of education. But yes, thank you.
Okay, so Linda, do you think we need a formal resolution? We're going to need to, I think, bring this back to the working group at some point as an amendment.
I don't know that we need a formal resolution. I can draft. Well, first of all, I just want to make sure we hear from Claudia and Judge Harper whether you agree with this. And as far as I can see, C also qualifies currently, doesn't it?
Yeah,
Yeah.
Yeah, we
So
included that on the
So
original.
we're just, it's just B is
Yeah.
what we're
We're
adding.
just down it, yeah.
Well, if you compare subsection C and subsection C with 6450, the paralegal, the language is different. And this one just broadly says institutionally accredited. And then for 6450, it says, let me see this one, a certificate of completion. And so it's a little bit different. It requires.
Oh, I know what the difference is. It's then what it would do is for these, especially private schools that have been offering paralegal programs, but they have not been accredited by a post-secondary entity, they do not qualify, giving their students qualified under 6450 C2.
Got it.
So it
Okay.
is different. The requirement is higher because of the accreditation that they have to have as an institution.
Got it. Okay. All right. So I think so we are saying we're adding 6402 B and C. So Claudia, is
Well,
that
can I just interject? Stephen, does that change your mind in any way now that I noted the difference?
On subsection C?
Yeah, that this means that, say, for example, there was one of those colleges that issued a certificate of a completion, but was not eligible to be certified under an accrediting board of the state of California. It would mean they would be also eligible under what we're just saying right now.
Yeah, I didn't want to backslide, but I did have, when I saw that not is institutionally accredited, but not ABA approved. What does that mean?
No. Okay, so I think what we should say is that that institutionally accredited, I have no idea what that means. If it means the same thing as we looked at in 6450, I'm not as familiar with the LDA statutory scheme, but I guess what I'm saying is if the term institutionally accredited is defined as what we saw under 6450 C, whatever that was that you were showing, Linda, if those are synonymous, that would be my intention, that institutionally accredited means someone who could have been a paralegal under that subdivision of 6450.
and 6450 says that has been accredited by a national or regional accrediting organization or approved by the Bureau for Private Post-Secondary and Vocational Education. So national or regional accrediting organization, is that the same as what we think it
We
says?
can say, well, I think we could say for our purposes, that's what our intention is.
Yeah, I think you're all right about institutionally accredited. For example, the art schools, we have the WASC, the Western Association of Schools and Colleges. We can be accredited by them. That's the institutional accreditation. But then let's say you have a program there like interior design, and then they have their own licensing entity, like the ABA thing. And maybe they're not accredited by them. It's that kind of situation. You can be accredited by the institution that regulates the school systems, but not necessarily the licensing subset that regulates that specific profession.
And that's exactly what we were, Claudia, before we were ABA approved. We were certified under that same, the Western Colleges, WASCO, or whatever that is.
Right. Yes,
Yeah.
exactly.
And
And
it's
which
the
is
same
not
amount
easy.
of
That's
units.
hard too. Yeah.
Yeah, same amount of units, 24 units. So that's fine with me. But yes, so we used to be an accredited paralegal program under that regulation. Now we're under that one as well as the ABA.
Yeah. Just a little more stringent, right?
Yes.
Okay. Is there just a question going back to the subset A? I know that you all mentioned not wanting some of these folks to maybe speak up during court, have the in-court representation.
Well, that was, modified.
around with the not allowing them to participate in the court representation? Like, would that be possible? I know that makes another complication, but
Well,
Yeah,
I think
is that
you
a
were
way
at
to
the
help
meeting
them?
on Friday.
I was
Claudia.
not. I'm sorry about
The
that.
meeting on Friday, what was adopted was to allow paraprofessionals to provide full in-court representation in Superior Court.
Oh, okay.
There's an exclusion for jury trials, and there was
Good.
also provision that the practice area subcommittees could make an alternate recommendation
Great.
with a rationale for that. So I think that's what's leading to Stephen's reluctance to allow people with a high school, just with a high school diploma, from if there's a possibility that they might then represent people in court.
Understood. Thank you.
Mhm.
Judge Harper.
I'm comfortable with, as Stephen laid it out, the B, C, and D as stated to be included. I agree that it's a lot to ask of a high school diploma and to go through this program and then be able to appear in court to do everything but jury trials. I think that the B, C, and D, the requirements for those, I think, make you more ready to be prepared to do all aspects of the job. So I'm feel comfortable with including the B, C, and D as well.
Okay. So I can draft a memo and I will circulate it, just amending the eligibility requirements, the prerequisites, and get your feedback. And I guess we'll present this, we'll add this to the agenda for the April meeting.
Yes.
Perfect.
Okay.
So do you want to deal with the comment we received from the California Paraprofessional Association? I'm not sure I fully understand what the recommendation was, other than perhaps a different understanding that ABA certified and certificated is not the same thing. Right?
Yeah, it's not. And I guess the difference, I'm not an expert on the difference either, but my belief is that CAPA has a test that you can take that is probably even higher. And in fact, I want to say, as I recall, you have to have certain years of experience to be able to take that test. So I guess my feeling would be, and NALA is the national organization, and I don't think that we're here looking to have out-of-state paralegals come to California to become paralegals. The only people we are looking at are LLMs perhaps, which is a whole group by itself. But I think to not confuse what we're interested in, we want folks that are paralegals under California law. If they've taken it upon themselves to get statewide or national-wide certificates, terrific. But I still think all of them have to go through the waiver process of having the state bar look at their transcripts and or whatever else they took as a result to pass those other certifications, to be evaluated to see if they can waive out of taking another course. I just don't think that automatically they should be qualified to forego the educational requirements.
So currently the waiver allows people to take to apply for a waiver based on courses they took as part of their paralegal education program. So do we want to expand that to allow them to apply for a waiver based on a course that they took towards this certification?
My understanding would be that I'm not positive that you have to be a paralegal of California to take all those tests. I think that may be welcoming, and I'm not positive, so this is not learned comment, it's just a statement, What I would not like to see happen is somebody who has a NALA certificate coming from Nevada, Idaho, or Colorado saying they want to enter in with this, but have no knowledge of California law.
So we have a hand raised in the attendees that I don't remember if Karina, I don't think that's the woman we spoke to, Linda.
I don't think so. Shall I invite Karina to address this?
If it's on this topic, maybe it would be helpful.
Okay.
Sure.
Hi, Karina.
Hi there, can you hear me?
Yes.
Hi. Great, actually, it was in fact on this very topic, on the topic specifically of allowing folks with high school diplomas to become LDAs. Just wanted to expand a little bit on this subject. I know that it's kind of already been passed over. I think you folks are in agreement with what the requirements should be. But it's similar in a gap to access to justice. There is a gap in access to education. And so I think that there are some folks who are quite capable and would otherwise succeed in higher learning if only they were afforded the opportunity to learn. It's no secret that higher education is more expensive than ever. And so increasing the application pool may also increase access to justice. These individuals would still need to pass the exams, just as a graduated paralegal would. And to Elizabeth's point, there is something to be said about establishing soft skills beforehand. So just wanted to throw that out there as someone who is currently only holds a high school graduation certificate, that I think I've done pretty well for myself over the years. Actually, for many years, I was an employee of the state bar and am happy to be a sustaining member of CALDA currently. And so I look forward to seeing more access to justice through the licensing of paraprofessionals. I also look forward to seeing folks take into account the gap in access to education. So that's all that I wanted to say on that matter.
So it sounds like there's not, she doesn't know about Kappa, which was what we were discussing.
Sorry.
Yeah, Kappa and NAFLA. So, I mean, unless we're going to take additional time to investigate that, I just think that with the ones that qualify as California paralegals, the way we have it, if they have additional certification, that can be considered through the waiver program. But outside of giving it credit for that purpose, they still have to be paralegals. So
I didn't hear anything in the video that would cause me to revise our recommendations, which have already been approved.
yep.
Yeah, I agree.
Okay. Great.
Okay.
All right. Thank you.
Thanks, Elizabeth.
Hey, everyone.
Thanks. And thank you, everybody, for doing this at 5 o'clock in the evening. I appreciate it. I had a real scheduling issue if we tried to do this during the daytime this particular
Well,
week.
you've got the perfect background. We just need to
Yeah.
hear tequila sunrise, 5 o'clock somewhere.
Yeah.
I really liked your background, Stephen. Thank you.
Is that where you are, Stephen?
That's the rework here at Pismo Beach.
Thank you.
Beautiful.
That's how
Is
you
that where
doing.
you are, Stephen?
Yeah, I'm in Pismo,
Which hotel?
my house.
Oh, yeah, well, I'm at Pismo Beach, not in my house.
Oh,
Wait, Julia.
Okay,
Where
we're
you
still
at?
in a public meeting, just so
okay,
you
all right,
know.
bye.
Yeah.
All
We'll
right,
talk.
thank you.
Bye.
Hey, Julia, call me on the phone.
Bye.
Okay.